Barry, why don't you call the case, though? Let you do that.
And we are live and on the record. This is case 2021 J0014.
Thank you, and good afternoon. Welcome to the appeals court session for February 3rd. I'm Greg Massing. I'll be your single justice today. We have pretty formal procedures when we're doing a regular argument. We'll be a little less formal today. However, I'm gonna only one party is gonna talk at a time, and the other party will have plenty of chance to respond.
Sorry about that.
Okay, and for the purposes of this, so this is Mr. Griffin's appeal of the denial, the housing court's denial of his motion to stay levy of execution. The attorney Heck, for your clients, you have up to this point not attempted to levy an execution because you wanted to make sure that it was complying with this court's orders as well. We appreciate that. But so, and there are a number of issues that are here. And how I'd like to proceed today is actually, even though it's Mr. Griffin's stay, I'd like to have Attorney Heck go first and sort of give me the procedural background. And also, so I've got your response, and you do make an argument that the CDC moratorium doesn't apply to use and occupancy payments. I want you to assume that I don't agree with that, and that I think that the CDC moratorium is broad enough to cover use and occupancy payments. So when you're going through, I'd like you to. I know you mentioned there are lots of other reasons you say that this is not a non-payment case, and so I think if you could focus on those, that would be helpful. So, but start with this. Give me the layout of the nature of this building and Mr. Griffin's unit and the history of the case. And I think it started with your client purchasing the property.
Yes, Your Honor. Thank you. And if it pleases the court, my clients purchased the condominium the two-bedroom condominium that Mr. Griffin lives in out of foreclosure. At the time, Mr. Griffin was a tenant in the unit. I don't believe he had a lease. My clients then started a eviction action against Mr. Griffin as just a tenant at will. And it was worked out where they agreed to sign a lease to let Mr. Griffin stay. They agreed upon the rate of $800, and that lease went into effect. After the first year, and as Mr. Griffin has mentioned in his various filings, a prior attorney to myself, they sent a notice to terminate the lease, but it was ultimately determined by the housing court that the notice was not sent in accordance with the terms of the lease 30 days prior to the lease ending. So the 2018 eviction case was dismissed. So at that time, Mr. Griffin was aware that the landlords wanted him out, but he got a stay or a reprieve for the 2018 year. Flash forward to November of 2018, the landlord, the appellee, did properly serve him with a notice of termination that his lease would be ending at the end of the term, which was December 31st, 2018. This was one of the issues, and this was the sole issue for the eviction case, a no-fault eviction under the contractual terms of the lease, that the term of Mr. Griffin's lease had expired, and it was time for him to move out. He did not move out, and the eviction action, the complaint was filed, and ultimately we've proceeded through 2 years of litigation, starting in February of 2019 to where we are here. Is that the foundation you're looking for? Or do you want me to go through the whole process?
That's helpful. That's helpful.
Okay.
No, that's good enough. That's good enough. And then, so tell me, so that ended in a judgment when?
On December 26th, 2019, Judge Malamet issued a judgment of possession in favor of the landlord, the plaintiff, and also denied all the counterclaims of Mr. Griffin. He corrected his findings of fact and rulings of law, which were issued on December 26th, on January 7th. And the corrected findings of fact and rulings of law, I think there were some citations that he wanted changed and whatnot. That is the document that I filed with my record appendix in this case.
Okay. And then there was a notice of appeal filed from the corrected judgment.
Correct.
And some more time was given at that point.
Yes.
So
He filed his notice of appeal also on January 7th. He also filed for waiver of appeal bond and use and occupancy. We had a hearing before Judge Horn on January 10th on that issue. Judge Horn at that time waived the appeal bond, but said she would listen to use and occupancy as to what the rate should be set at. Mr. Griffin at that time did not have any documentation for the court. Judge Horn then gave him leave of 2 weeks to submit any evidence that he wanted to provide with respect to what the appropriate use and occupancy rate for the apartment would be. Mr. Griffin failed in those 2 weeks to provide anything. I believe he filed a motion for more time. Judge Horn denied it and issued use and occupancy of $1,150, which was based on Judge Malamut and his findings and facts of ruling of law. He suggested that any further issues with respect to use and occupancy is there's a housing and urban development small zip code, and you have to forgive me, I'm forgetting what it was, but it was a metric for determining in this very specific zip code what the average rent would be. So the 1,150 was ordered. Mr. Griffin then appealed it to the single justice of the appellate court. We were before Judge Ditkoff on that. On February 25th, we had a hearing where Judge Ditkoff ruled that the 1,150 was appropriate. Judge Ditkoff then ordered that since it was so late in the month of February, Mr. Griffin would be allowed to pay his $800 for March, but starting April 1st, he would have to start paying the increased amount of $1,150. Both, and I think it's important to point out for what we'll get into later, that at both the January 10th hearing on the use and occupancy, as well as in the appellate court, Mr. Griffin did inform the court that he only got $900, give or take, in Social Security disability, and that number's been the same since. So that leads us up to the end of February. On March 23rd, I then filed my Mass Rules of Appellate Procedure 10C motion to terminate his appeal for failure to comply with Mass Rules of Appellate Procedure 92. What 92 requires is within 14 days of his filing his notice of appeal, he either has to A, provide the transcript of the case to the court, B, he has to file an affidavit with the lower court of that he has ordered the relevant transcripts that he's going to use, or C, an affidavit that he would not intend to order the transcripts for the use in his appeal. That was scheduled for a hearing, but the hearing was continued till May 6th because of the first delay of COVID-19. Subsequent to that, in mid-April, when he hadn't paid his use and occupancy in full, the full $1,150, I then filed a second motion to terminate appeal on the issue of use and occupancy. Both were to be heard May 6th. In or about April 17th of 2020, the mass moratorium, as it's called, went into effect, basically putting a stay on all eviction cases in Massachusetts. Nothing could be done, no hearings, not just evictions, nothing could be held. And that moratorium was in place until August, and then they extended it until October 17th, which was a Saturday. On October 19th, upon the instruction of the court, even though those two motions had already been filed, the clerk's office in the Central Housing Court requested that I refile the motions. So on October 19th, I refiled both motions, the motion to terminate the appeal for failure to comply with the rules of the appellate court, as well as for the failure to pay the use and occupancy. At that time, and this is where my outline of facts and Mr. Griffin's differ, at that time, I filed an affidavit that I had not received the CDC affidavit on instructions. Once Mr. Griffin received my filing, he then filed his CDC affidavit, which is one of the issues in this case. And then I filed an updated affidavit that said, well, now I have received it. From there, we ultimately, and you'll have to forgive me on the dates, I want to say that was October 19th. I want to say it was right at the end of October, the court held a hearing on the two motions. It's important to point out that with the Mass Rules of Appellate Procedure 10C, it specifically points out in the statute or in the rule that should the issue of 92 be the reason why the 10C motion is being filed, if the appellant serves the court or files with the court the affidavit or the transcript or whatever he's supposed to do, if he cures that before the hearing, then it's deemed to be timely. So at the hearing, Judge Horan asked Mr. Griffin what had he done to comply, and he didn't have an answer. He didn't do it. So from March 23rd, when he was put on notice for the reason why the filing, the motion was in place, all the way until October, the end of October, even after the motions were filed again, he still had not taken the simple step of either, getting the transcripts, which we all understand can take a while, but all he had to do was file an affidavit that he was ordering them or he wasn't intending to order them. He didn't do any of that. So at that time, Judge Horan ruled on both motions separately and independently. She terminated his appeal pursuant to Mass Rules of Appellate Procedure 10C for failure to comply with 9D2, and she separately, and there are two different rulings or orders, she separately terminated his appeal for failure to pay the full amount of use and occupancy. At that time, in terminating the appeal, she granted him a stay until January 1st. So that brings us up to that point in the case.
And did Mr. Griffin file a notice of appeal from the dismissal of the appeal?
He filed a notice of appeal and he filed a request for a hearing on appeal bond, but the lower court didn't do anything with that. And I will point out that once again, here we are, that was in early November, December. Here we are almost 3 months later, and he still hasn't requested a transcript or complied with 92 yet again. So the appellees were almost playing whack-a-mole with these appeals. It's like he files the appeal but doesn't take the appropriate action. And in my discussions with the with the housing court, that appeal requesting the review of that, it did not affect that an execution was to issue. So because the execution was going to issue, I did not again file a 10C 92 motion to terminate the appeal. I'm not even sure what the appeal was. All it said was I appeal. He didn't put in any of the issues or what specifically he was appealing. And I think it's important to point out that at that juncture in the case, when the appeal was terminated, while the appellant has repeatedly filed with this court that his appeal was terminated for failure to pay use and occupancy, that's not factually true. The court in looking at the record, I provided the documentation in my record appendix. His appeal was terminated separately and distinctly because he had failed to comply with the rules.
There's a lot of facts here, and I think in a minute, I want to give Mr. Griffin a chance to respond. There's a lot to remember. Has he been paying the 800 monthly, or have you been receiving that monthly?
He paid the 800 monthly up until November, December, January, and now February. He has not paid. In January, when at one of the motions to stay the execution, in January, Judge Horan specifically asked him that. He said because of his medical condition, he doesn't have a bank account, but then he later said that, well, he doesn't want the other side to have his banking information, but he said he didn't feel safe going to the post office, so he hasn't mailed the money orders like he normally did. Judge Horan asked him, well, have you reached out to the plaintiff to arrange for them to come and pick up the payments? And he said, no, he had not.
Okay, so I'll get back to you, Attorney Heck, but let me hear from Mr. Griffin for a bit here. So, Mr. Griffin, with respect to that recitation of what's gone on in the case so far, is there anything there you want to respond? I noticed you shaking your head a couple of times.
Yes.
So, go ahead.
Good afternoon, Your Honor. First, I'd like to start with a statement that, as I've made it very clear in the past, I'm not looking to stay here forever. In both mediations, as well as in the court, I've consistently said that I am, in fact, looking for a new place, looking to move out. But in order to do so, as an indigent person, I would need the vital Section 8 housing voucher. In order to do so, as well as moving costs upon finally finding a suitable home that meets my needs. As you know, the move would be permanent at this stage of life. If we could go over the facts that Mr. Heck just explained, I'd like to give you the more accurate version. Yes, Mr. Ghazaryan and Mr. Balian did purchase the property in 2016 from Fannie Mae after foreclosure, after the bank had illegally shut my heat off. The head of the housing department, I believe it's the housing department, Lee Hall, was going to file criminal charges against Fannie Mae. At that point, Fannie Mae dumped the unit for half its value, whereupon Mr. Ghazaryan wanted to purchase the property from Armenia. He had sent his partner, friend, here to Worcester to purchase this property in Worcester at a song. He did so. Mr. Balian filed a summary process against me. We met up in housing court. We went straight into mediation. In the mediation, I was asked, how much were you paying to your previous landlord? I said $800 a month with utilities included. Mr. Balian wanted $800 a month, period. So we had made an agreement. The court had blessed the agreement, and then we had signed a lease. At that point, after signing the lease, Mr. Balian had come over to the house to make some repairs. Rather than hiring outside contractors to do the repairs, he prefers to do them himself. On the second time visiting, he came to fix a window that was broken. When he came over to fix the window, at some point during the morning, Mr. Balian wanted to get into something in flagrante delicto with me. I poo-pooed his advances, which is a fact. And after that, whenever there was a question asked of me from Mr. Balian, the property manager, the only person I've really known as far as being, one of the partial owners or property manager or whatever the story is at the moment, he would yell. For example, he wanted a copy of the keys. I thought I only had the one set of keys. I forgot that I had a second set in my dresser.
Mr. Griffin, I'm gonna stop you for a second here. So it seems to me that you've got some disagreements with the landlord here, but it's at some point it sounds like they told you it's time they're going to terminate the lease. Right.
Yes, Your Honor, but there's a few.
And they can do that without, so no cause. They didn't say that you did anything wrong. They just said it's time. It's that we don't want to lease you anymore, right?
Yeah. Well, one fact that Mr. Hecht forgot to mention was that in the second trial, it was discovered that the landlord's second of three attorneys was actually, in fact, a witness, and Judge Horn had to halt the entire trial until Mr. Attorney Hecht came on to take care of the situation. And excuse me, if you can give me a second here to look at my notes. Okay, let's see. Good afternoon, Your Honor. Okay. Oh, excuse me. After the unwanted advances came to me in and around early February of 2017, Mr. Balian, the landlord's property manager, had continued to try to get me into signing a new lease. He was like a consistent thing. He wanted a new lease. He wanted a new lease. He wanted a new lease. I'm not saying the man has anger issues, but and finally, I was, I have a friend, or had a friend, who was in treatment for cancer, and the friend was close to passing away, and I was buffaloed into just simply signing the lease, where the original lease had stated that it was a self-renewing lease, and then the second lease, which was a lease that he had fashioned more, to what he would desire for the lease. Judge Horan did rule on the fact of my being sexually harassed by the plaintiff, Mr. Ballion, in the case. She awarded me thousands in damages because of this. And also at the same time, she awarded possession to the plaintiff. I went and filed for reconsideration with an LAR attorney because of the fact that Judge Horan had agreed to the truth that I was being harassed. There's also a stay away letter filed at the Worcester Police Department because I found Mr. Ballion, as well as his girlfriend, fiance, friend / attorney in the case, sitting outside the house, watching the house in their car. I do have the footage on video. And so Judge Horan had sided with me as far as the harassment, but she didn't really know what to do as far as possession, so she gave it to the landlord. At that point, like I said, I filed for reconsideration with an LAR attorney. I was denied without a hearing, yet Attorney Hecht had filed for reconsideration in the case, even though his client was given possession. But at that point, Judge Horan did in fact allow another hearing, or a hearing for Mr. Hecht's reconsideration of the case he just won, outside of the damages that were awarded to me. The LAR attorney that I had at the time believed that since Judge Horan was in fact siding with me over the fact that I was in fact being harassed in myriad ways, that she has to give me the whole kit and caboodle, meaning possession as well as the thousands in damages. But when I brought that in with the LAR attorney under reconsideration, she poo-pooed the whole thing. And at that point, threw the whole case out.
Who poo-pooed it, the judge or the attorney?
The judge.
Okay. So I mean, let me try and speed this up a little bit. So you've got a judgment against you, and maybe there's a judgment for you as well. There's a judgment, and you file a notice, and you file a notice of appeal from it.
Correct.
So, and with that as well, they waive the bond, but they increase the use in occupancy.
Correct.
And so that's going forward, and then around this time, a pandemic hits.
Yes.
But so, what about, how do you respond to it was later dismissed for not taking actions to get a transcript under Rule 9D?
Excuse me, Your Honor. I did in fact file for the transcripts. I did file for the transcripts because there's so many out there that would have to receive. At some point, I just petered away because it was too difficult for me to do all the administrative stuff. I'd like to also address, as far as the use and occupancy, the use and occupancy was set at, excuse me, my mouth is very dry from issues. The use and occupancy was set at $1,150, $350 more than I am given a month from the government because of my diagnosed disabilities. And I mean, in a way, you could say that's almost constructive eviction, to say, okay, well, this is the amount he's been paying, and all of a sudden, let's just ask for $350 more. In the first mediation out of many mediations that I had with the previous attorney, in the case Natalia Collada, the reason why we had so many mediations is because the attorney at the time, the second of the three, did not want to go before Judge Horan again after being excoriated for not getting her numbers correct in the first hearing before a trial. I'm sorry, what was I saying just before that?
I was asking you about whether you had complied with Rule 9D2 in perfecting your appeal. And you said that you did file transcripts, but also that there were too many, so you didn't. I didn't quite follow that.
I mean, I guess I may have dropped the ball, but I did in fact file for the transcripts. I'm sure there is record of this. Thank you for bringing me back on point. So as far as the use and occupancy payments, obviously, if I make only $892 a month or thereabouts, paying $1,150 was something I couldn't do. And that's the point that I wanted to get to. And the one and only mediation that I had with Attorney Hecht, I was suddenly asked to pay $1,150 a month.
Let him finish. You can let him finish your trade.
This is confidential.
Excuse me, Your Honor. Whenever I start making a point, I notice it because Attorney Hecht will suddenly speak up. So I was.
Let me wait. I am gonna. He's raising a privilege type of issue. So
any discussions in any of the mediations are confidential. They cannot be used in court. We're given specific instructions.
I didn't know that, Your Honor.
And we've discussed it in court on numerous times, but I would argue that whatever offers were made or whatever was discussed in the mediations, not only is it confidential, but it doesn't affect anything that happened with respect to the case. Thank you, Your Honor.
Okay, thank you.
Okay, may I go on, Your Honor? I want to address something that Attorney Hecht has said. I want to clarify for the court. Yes, I have in fact been paying the $800 a month all the way straight through, even when the use and occupancy was set at $1,150.
As far as with me I'm concerned, you really don't have to worry about the 350 because I'm sympathetic with you on that.
Thank you.
And for these purposes only. But what about did you stop paying in December?
That's what I'm trying to say, Your Honor. Because of if you were to refer to medical letter 1 from my physician, it'll explain a lack of something, and that's why issues have been exacerbated. In November, when I went as usual to send off the $800 money order, when I went inside the post office, it's located on Main Street in Worcester, in Webster Square. The post office is very small inside, and so it's very long. So they only had one person working the counters. It was a very long line of people. There were people without masks on inside. There were kids running around, just running up and touching people and things. And it really set some of my issues into overdrive. As you can clearly understand, I hope, I'm definitely worried about the coronavirus. At that point, I physically couldn't go inside. If the court were to subpoena records from the U.S. Post Office to check their video footage, they would find me on different dates outside of the post office looking in to see if it was packed or not, so I could easily physically get in, get the money order, and then get out. I have held on to the $800 from December, January, and February. And also, excuse me, give me a second, please. As far as the quote unquote banking issue that was mentioned, I do not do banking. The banking was mentioned by me in court because in the period of early 2017, when the plaintiff, Mr. Ballion, was pressuring me to sign a new lease at a different amount that he wanted, he asked me about my banking information, and this was not a person that I was going to give any sort of sensitive information to. And I told him straight up, I said, I don't have a bank account. I don't do banking. My money is basically through a debit card, and I pay my bills, via USPS money order. So it's therefore trackable. Because at one point, Mr. Ballion had said to me, well, this money order, this is like cash. What if I were to lose it? I could always just say that you never sent it. And at that point, I knew that this was definitely, someone that I would have to be very careful with. I think I covered most of it.
Okay. Let me see if you have any questions. So I don't think I do. Mr. Hecht, anything you'd like to respond to or add?
Well, I mean, there's plenty more to cover, but you're talking about just with respect to this latest thing. I mean, what I will say is with respect to Judge Horn's first decision, as Mr. Griffin pointed out, counsel for the plaintiff at the time, Mr. Griffin brought up some issues where she may become a fact witness. So Judge Horn paused the trial, instructed my client to get a new witness. That's when I was hired. We then went to start, I contacted the court and was told we were going to start the trial over. When we showed up at court, Judge Horn said, no, we're just going to continue from where we are. So we went through the trial and Judge Horn did make the decision. And if you look in the record at her decision, she ruled for possession, but she also found that because my client did not deny the issues raised by Mr. Griffin, she ordered 3 months rent as damages. The reason why we had to go in and appeal that was because if the money owed to the landlord is less than the money owed to the defendant, then we wouldn't have gotten possession anyway, and that would have been the next level of appeal. So my motion for reconsideration, I pointed out to Judge Horn that my client did in fact, in the first half of the trial, which was a month or two beforehand, he did deny the allegations on the stand. I don't know if Judge Horn had listened to that or not, but when she heard that, she said, you're right, the plaintiff did not get a fair trial, and she ordered a new trial to be heard by Judge Malamet. So that brings us up to his appeal being dismissed.
I'll get back to you, Mr. Griffin. Let me let Attorney Hecht finish. When was that trial?
I want to say that trial took place in either June, I think it was July of 2019.
Okay, and that's not but the final judgment was a different trial that took that.
Yes, we had a new trial that started in September and took place over, I want to say, 4 or 5 different sessions. Mr. Griffin could only do afternoon sessions, and so Judge Malamet ordered afternoon sessions. The first session we were going to start at 1 o'clock. Mr. Griffin was late. He didn't have his evidence. We lost the time that day. And eventually, Judge Malamet actually was moving to the Eastern Housing Court. So the hearings were the trial was to continue in the Eastern Housing Court. Mr. Griffin requested that he couldn't make it to Boston. So Judge Malamet actually worked his morning session in the Eastern Housing Court, drove on his lunch break out to Worcester, and we did the trial in the afternoon in the Central Housing Court to accommodate Mr. Griffin. Judge Malamet, the trial finished. Judge Malamet rendered, I want to say it's like an 18-page finding of facts and rulings of law that address most of the issues Mr. Griffin has brought up, and I will just stand on what Judge Malamet eloquently wrote with respect to all these issues.
I don't know if I might have a copy of that in the record, but could you please submit that so I can take a look at that?
Submit
the Judge Malamet's 18-page decision.
It's in my record appendix.
It's in your record appendix?
Yes.
Which is okay. Which was filed around. Oh, I can't really tell from this.
The record appendix, it starts on page 3. Judge Malamet corrected findings of facts and rulings of law.
Okay.
I can still submit it again if the court.
No, that's fine. I'll be able to find it.
Okay.
So why don't we just finish up? You said there's a lot. Address Judge Horan's final decision. I guess did I remanded it for clarification, and she. So if you could address that.
Yeah. Well, Mr. Griffin is making the argument that the CDC moratorium applies to him because he has failed to pay use and occupancy. The CDC moratorium. The CDC could have said, we're going to stop all evictions, any eviction you want. They did not do that. They gave very specific coverage for what evictions would apply to the moratorium. We know that because there's an applicability section of the moratorium. And in the applicability section, sorry, difficult word to say, it's they listed out 5 specific things that would not be covered, i.e. if the tenant is committing crimes, if they're violating zoning. But one of them in particular, the one that applies here, is number 5, where it says violating any of the contractual obligation other than timely payment of rent or similar housing-related payment, including non-payment or late payment fees, penalties of interest. So what they're talking about is exactly what we have here. we have a contractual issue, i.e. the term of the lease. The lease was up. The lower court has determined that the lease was properly terminated in accordance with its terms. And as of December 31st, 2018, the contract was over. Mr. Griffin no longer had a contractual right to be in the unit. So because the CDC says that, this case does not apply to it. This is a case that just deals with the contractual obligation. Judge Malamet, in his findings and facts, the ruling of law that we were just discussing, talks about it. It's a no-fault eviction. So now Mr. Griffin says, well, I haven't paid use and occupancy, so now the CDC applies to me. But as we've kind of just gone through point by point by point, every decision point in this case was decided by something other than Mr. Griffin's failure to pay his use and occupancy. His appeal was terminated because he didn't follow the rules of appellate procedure. We then get to, after the appeal was terminated, he was granted a stay. He then asked for another stay. And Judge Horn denied that for two reasons. One, because no, he hadn't paid his use and occupancy, but also pursuant to Mass General Laws 235, is it 235 Section 9 or 239 Section 5? Forgive me. 239 Section 5. That statute also calls for, that statute in requesting a further stay also calls for certain obligations of the tenant. Judge Malamet, in his findings and facts of rulings of law, he issued a stay. Mr. Griffin is before this court saying, I wasn't given a stay. Judge Malamet, back in December 26th, corrected January 7th, he issued a 2-month stay to Mr. Griffin. And he said to Mr. Griffin, look, I understand you may want to extend this stay pursuant to the statute, but in order to extend this stay, you have to keep a log. You have to keep a log of everywhere that you've contacted, names, phone numbers. There were very specific requirements in order for him to be eligible for a further stay, having already received one. Mr. Griffin didn't do that. And Judge Horn asked him what he had done. There's no log. So when it came time for Mr. Griffin to...
That's efforts to find another place to stay.
Correct. Correct. He was supposed to find other apartments. And Mass General Laws 239 Section 10 specifically points out that, I'm sorry, forgive me here, Your Honor, let me just find it in my notes. Section 10, he's required to keep a log and provide the same court with requesting any further. On a hearing about this, the court can make a determination about compliance. The court can determine whether he made reasonable efforts, and that's what Judge Malamet wanted. That's why he said, the court is open to granting you a further stay beyond the 2 months that we did, but you got to keep a log. And Judge Horn asked him about the log, and he didn't have it. This isn't a situation where Mr. Griffin submitted a log, and the court said, well, that's just not sufficient. He provided nothing, much like the rules of appellate procedure. It was that simple. All he had to do was provide the court with a log. He didn't do it. So that's why Judge Horn denied his request for a stay. There's also the use and occupancy issue, but separate and distinct from that is his failure to comply. The statute says that the court can require certain actions of the tenant in order for a stay to be granted. Judge Malamet even said to me, if he does not comply with this, you can request an execution. It's in the findings of fact, rulings of law towards the end. Now, Judge Malamet also said I could request a copy of the log from Mr. Griffin, which I did, and I emailed him, and he never provided it to me. So that's the CDC moratorium. I don't think it applies because it's a contractual obligation, and every step of the way it was non-use and occupancy issues why Mr. Griffin is now, why I have an execution in my possession. The other issue is, even if this court were to determine that the CDC moratorium does apply to this situation, the CDC requires a declaration. And I've questioned the veracity of Mr. Griffin's declaration. Specifically, the declaration says you have to sign under the penalties of perjury that all of the following are true. And the one that Mr. Griffin left out was, he says, it's number 3. It says the applicant is unable to pay full rent or make full housing payment due to the substantial loss of household income, loss of compensable hours of work or wages, a layoff, or extraordinary out-of-pocket medical expenses, which the CDC requires as 7.5% of his adjusted gross income. So Mr. Griffin, under oath, signed the declaration that this was true. Now, we've already established, and Judge Horn, in her response to this court in footnote 5, pointed out that he was on Social Security disability. He was getting the same amount prior to the CDC moratorium. He's getting the same amount now. He hasn't had a reduction in income or extreme medical bills. So if the CDC moratorium applies, which we argue it does not for the reasons stated, then this declaration is invalid. And I go as far as to say that, a hearing on this issue isn't even necessary, because Mr. Griffin, in his correction that he filed early this morning, I want to say it was in paragraph 7 of his correction. Let me see here. He says, I'm sorry, Your Honor, the clarification, paragraph 7. In this case, the defendant meets every criterion except potentially one. So having already signed under the penalties of perjury that he meets every criteria for the CDC declaration to be valid, he now admits that, well, maybe one, but the defendant starts with an acknowledged limited fixed income. He then goes on to ask this court to say, well, the CDC must have intended for this group that I'm in of people who are on a disability fixed income, the CDC must have intended for that to apply to this moratorium. But I would argue, no, they did not. They gave very specific reasons why somebody could be covered. Should they be covered? I don't know. That's not my decision. The CDC gave very specific terms. And Mr. Griffin is asking this court to not just say, well, the CDC moratorium is confusing and we need to clarify what some of the language in says. He's saying that this court needs to expand what the CDC is saying it wanted to cover. If the CDC wanted to cover people with a fixed income, they would not have required this. So my position with respect to the CDC moratorium, it does not apply. But if this court were to determine that the CDC moratorium might apply, his declaration is invalid, and therefore he's not eligible for it anyway, because he does not meet the criterion in the declaration, which he signed under the penalties of perjury and now admits may not, actually doesn't cover him. And with respect to that, I'll turn it back to the court. Thank you, Your Honor.
Thank you, Attorney Heck. Mr. Griffin, you can respond.
One thing that's been consistent since Mr. Heck has been employed by Mr. Ghazaryan is that any disability, emotional issues that I have, which have been found out, he's tried to use them against me. For example, in the past, when he was asked a question, he would give a simple explanation, but now he just goes on and on and on, where I can't even remember what the first thing that was said was. Is in regards to the CDC declaration, I was the first one to file it. I'm pretty sure that I filled it out properly, as I had someone to help me fill it out. I would not try to perpetrate any sort of law or fraud, perpetrate any sort of fraud or lie to the government or to the courts. I did file it and send it to the landlord. The landlord complied finally and sent their version back. But the whole point about the CDC moratorium is, I would hope that you would understand, Your Honor, is that the moratorium is made to prevent the spread of this deadly airborne pathogen right now. For example, if there's a man outside in my house in the street running around with a gun, and the police are telling everyone, stay inside to be safe, that is exactly the point of the moratorium. So to prevent homelessness, to prevent people from contracting the coronavirus, as well as from people spreading the coronavirus. Early on in the coronavirus, there was an article that was published here in Worcester, which read that 50% of homeless people in Worcester at this time have contracted the coronavirus. Given my medical history, as you've been able to see, Your Honor, if I were to catch coronavirus, it would be grave. And that is the point of the moratorium, is to protect people and their health.
Oh, okay, I hear you. Anything else you want to add?
I probably had a point, but I've forgotten at this point because Mr. Heck was so long in the tooth, if that's the expression.
I think that means old.
Oh, I'm sorry. He just went on and on and on. I mean, someone told me that court is all about theatrics, really, when it comes down to it. And it seems like, that's what we have, the accentuation of words and, and the inflections.
I think another point of the CDC moratorium, a combined point, is that a lot of people, because of the pandemic, were suddenly lost their employment or were therefore unable to meet their bills.
Mhm.
And I think the point he is making is that your income has not changed.
Yes, Your Honor, but the fact of the matter is that I have been paying the use and occupancy amount to the best of my ability. That's what I've been doing straight through. I've been trying to pay for the best of my ability. My survival checks or stimulus checks have all gone to ordering in food, as I cannot really go inside of supermarkets unless direly needed, where I go to pick up my prescriptions once a month. The whole point of it is to keep me physically inside and to not come into contact. My God, I won't even allow my own mother into the house because of the fact that she's no longer working with the district attorney's office. She's now a home health care aide, and she goes grocery shopping all day for the elderly. And because of that, I can't physically be around a person like that. I'm physically trying to stay away from everyone. I'm consistently wearing N95 masks because the other masks, which the police are giving out, are not effective. I've been told by a couple of doctors.
Okay.
I'm even been warned off.
I'm going to stop you there. I don't think that's really relevant to any of the issues that are before me. I mean, I understand that I understand your arguments about what the moratorium is for.
Yes.
Okay. All right. I think I understand both of your positions. And I'm going to take the case under advisement, and I'll get you a decision as soon as I can. I want to thank you both for your participation in this Zoom and this unusual forum. I think it was pretty effective. I think I understand what both of your arguments are.